6-3. The Supreme Court has a ruling today. U.S.-born children are U.S. citizens. The Supreme Court has just issued a major decision on birthright citizenship. June 30th, 2026. The Supreme Court supports the Fourth Amendment. The court rejected President Trump's attempt to restrict birthright citizenship by executive order. The ruling means that a child born in the United States and subject to U.S. jurisdiction is a U.S. citizen, regardless of whether the parents are U.S. citizens, green card holders, undocumented immigrants, students, workers, tourists, or other non-immigrants. This was a 6-3 decision. Chief Justice John Roberts, joined by Justice Sotomayor, Justice Kagan, Justice Kavanaugh, Justice Barrett, and Justice Jackson. The three dissenting justices were Justice Thomas, Justice Alito, Justice Gorsuch. This lineup is very important. It was not simply the three liberal versus the six conservative. Instead, Chief Justice Roberts, joined by Kavanaugh and Barrett, two conservative justices, both appointed by President Trump, joined the court's three liberal justices to reject President Trump's executive order. His executive order tried to say that a children born in the United States would not automatically be citizens if neither parents were U.S. citizen or lawful permanent resident. That would have affected not only undocumented families, but also families in lawful temporary status, including F1 student, H1 workers, L1 executives, J1 exchange visitors, and even some visitors. The 14th Amendment said it very clear. All persons born or naturalized in the United States and subject to the jurisdiction, therefore, are citizens of the United States and of the state where they reside. The court affirmed that this constitutional guarantee cannot be rewritten by a president through an executive order. The court also relied on the landmark 1988 case, U.S. versus Wong-Kim Art, which confirmed more than a century ago that a child born on U.S. soil is a U.S. citizen, even when the child's parents are foreign nationals. There are still very narrow traditional exceptions, such as the children born of foreign diplomats or children born to enemy occupying forces. But for overwhelming majority of the children born in the United States, the rule remains the same. Born in the United States means born a U.S. citizen. The significance of this ruling is enormous. First is draw a very clear constitution line against executive overreach. The president can therefore enforce the immigration law, but he cannot rewrite citizen clause of the 14th Amendment. Second, it protects not only undocumented immigrant families, but also millions of families in lawful temporary status. Many international students, H-1B professionals, L-1 managers, J-1 scholars, and other visa holders were watching the case closely because the executive order would have placed their U.S.-born children's citizenship in doubt. Third, it prevents creation of a second-class birth system in the United States, a system where two babies born in the same hospital on the same day could have different citizen rights simply because their parents' immigrant status is different. That would have created chaos, uncertainty over passport, social security numbers, school enrollment, health insurance, public benefits, and even basic identity documents. So today, the Supreme Court avoided that result. This is not just an immigrant-related issue. It is a constitution identity case. It answers one of the most fundamental questions in American law. Who is an American? And today, the Supreme Court answered it very clear. American citizenship by birth is protected by the Constitution. It is not something a president can take away by executive order. I'm Jing Amy Vang, immigration lawyer. Hope it helps.